Hi everyone, welcome to Legal Talks by Desi Kanoon. I am Suyash and today I will talk about the case of Ashutosh Ashok Paras Rampuria and another versus Messrs Gharkul Industries Private Limited, wherein the Honorable Supreme Court discussed the basic ingredients of offence punishable under Section 141 of the Negotiable Instruments Act 1881 that deals with offences by companies in relation to dishonor of checks. To know more about Section 141 and Section 138 of the NI Act, please refer to my earlier post accessible at the link provided in the description below. The facts of the case are not necessary for the purposes of this show and hence the same are not being discussed here. Before adverting any further, it is pertinent to note that Section 138 provides for the stipulations to be followed in case there is dishonor of a check. In the same way, Section 141 talks about the contingency when the offence under Section 138 is committed by a company. Section 141 further provides that a person will not be liable under Section 141 if he proves that the offence was committed without his knowledge or that he had exercised all due diligence to prevent the commission of such offence. But when an offence has been alleged against a company, who would be held liable in that company? Whether all the directors of the company would be liable or whether some other person would be liable. In order to understand this conundrum and Section 141 in a better manner, let us go through the pertinent observations by the court. Firstly, the court cited the case of SMS Pharmaceuticals Limited versus Neeta Bhalla and another, wherein it was held that under Section 141, it is necessary to specifically aver that at the time the offence was committed, the person accused was in charge of and responsible for the conduct of business of the company. This averment is an essential requirement of Section 141 and has to be made in a complaint. Without this averment being made in a complaint, the requirements of Section 141 cannot be said to be satisfied. B. Merely being a director of a company is not sufficient to make the person liable under Section 141 of the Act. A director in a company cannot be deemed to be in charge of and responsible to the company for the conduct of its business. The requirement of Section 141 is that the person sought to be made liable should be in charge of and responsible for the conduct of the business of the company at the relevant time. This has to be averred as a fact, as there is no deemed liability of a director in such cases. Thus, when a director is in charge of the company for the conduct of its business, such director may become liable under Section 141 of the NI Act. Secondly, the court observed that apart from asserting that the ingredients of Section 141 have been fulfilled, it is also necessary to show that at the relevant time when the offence was committed, the directors were in charge of and were responsible for the conduct of the business of the company. And lastly, the court noted that when a complaint is read as a whole and discloses that certain persons or directors were responsible for the conduct of business of company at the time when the check in question was issued and dishonored, then it would be improper to split such complaint to conclude that the allegations are not sufficient to fulfill the requirements under Section 141 of the NI Act. In such cases, powers under Section 482 of CRPC to quash the complaint must not be exercised unless the court comes across some unimpeachable, incontrovertible evidence which is beyond suspicion or doubt or totally acceptable circumstances which may clearly indicate that the director could not have been concerned with the issuance of checks and asking him to stand the trial would be abuse of process of court. Those were the observations by the court. So what are my concluding remarks? After reading this case, it is clear that the following ingredients must be satisfied to implicate a person under Section 141 of the NI Act? A. There must be a specific averment in the complaint that the person accused was in charge of and responsible for the conduct of business of the company. B. The person sought to be made liable should be in charge at the relevant time when the check was issued and got dishonored. C. A complaint under Section 138 and Section 141 of the NI Act can be quashed when there is incontrovertible evidence indicating that the accused person could not have been concerned with the issuance of checks. Therefore, I hope that the ingredients of Section 141 of the NI Act are clear by now. Hence, I hope you enjoyed listening to the show. Thank you for listening. Please do not forget to like and subscribe us. And if you have any comments, please make them in the comments section. See you next time. Till then, stay tuned.